Amendment 6. Right to speedy trial by jury, witnesses, counsel. Passed by Congress September 25th, 1789. Ratified December 15th, 1791. The first 10 amendments form the Bill of Rights. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by the impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have a compulsory process for obtaining witnesses in his favor, and to have the assistance of a counsel for his defense. Common interpretation. The Sixth Amendment by Stephanos Bibas and Jeffrey L. Fisher. The Sixth Amendment guarantees a cluster of rights designed to make criminal prosecutions more accurate, fair, and legitimate. But the institutions of American criminal justice have changed markedly over the past several centuries, forcing courts to consider how old rights apply to new institutions and procedures. At the time of the founding, there were local sheriffs but no professionalized police forces. Instead, ordinary men took turns serving as constables or night watchmen. Criminal cases were almost always brought by victims, not the public prosecutors. And the trial, neither side typically had a lawyer, so both victims and defendants represented themselves. Trials were like shouting matches, in which victims and defendants argued and brought other live witnesses to tell their stories. They lasted minutes or hours, not days. Juries for 12 ordinary men were central players in this system. They were local citizens who often knew the victim, defendant, and other people and places involved. They also knew which charges subject the defendants to the death penalty, as many felonies did, and which did not. Jurors looked at witnesses in the eye and debated both whether a defendant was factually guilty and whether he deserved mercy. They checked the government's power to punish and apply the conscience of the community in the public eye, assuring everyone that justice has been done swiftly, impartially, and fairly. The framers of the Sixth Amendment sought to strengthen this vigorous and adversarial process. Continental Europe had long used an inquisitorial system in which magistrates investigate crimes and judges take leading roles in framing the issues, digging up evidence, and questioning witnesses. The Anglo-American system, that is the Sixth Amendment codified by contrast, leaves it to each side to conduct its own investigation, present its own evidence, and argue one side of the story in open court. Most of the institutions of criminal justice changed greatly over the decades after the Sixth Amendment was enacted. Professional police forces came into being and took charge of investigating crime and arresting suspects. Public prosecutors steadily displaced victims and then defendants who could afford to increasingly hire lawyers to level the playing ground. In some communities, charities, or local governments set up public defender offices, offering free lawyers to all or some defendants accused of sufficiently serious crimes. Judges develop rules of evidence and procedure, and give the lawyers a say in selecting and instructing juries, so trials grow longer and more complex. To avoid the time and expense of jury trials, clear courts busy decades, prosecutor defense lawyers also increasingly plea bargained. That meant that most defendants avoided trial and plead guilty in exchange for lower charges or sentences. So by the mid-20th century, juries resolved only a small fraction of all criminal cases. Around the same time, the Supreme Court ruled that virtually every aspect of the Sixth Amendment applies not only to federal but also to state prosecutions. This vastly expanded the amendment's reach because most criminal prosecutions occur in state court. This incorporation of the Sixth Amendment against the states has also required the court over the past half century to spell out the amendment's protections and apply them to the variety of criminal justice systems across the nation. Perhaps the Supreme Court's most significant work has involved implementing the right to counsel. The court has confirmed that a defendant with enough money generally has the right to be represented by the lawyer of his choice. The accused also has an implied right to forego counsel entirely and defend himself. But what if a defendant wants a lawyer but can't afford to hire one? In Gideon versus Wainwright, 1963, the court held that such defendants facing possible prison times are entitled to court-appointed lawyers paid for by the government. Furthermore, such appointed lawyers, usually public defenders, must deliver effective assistance to defendants, meaning that they must adequately advise the defendants the potential consequences of pleading guilty and provide a reasonable competent defense if the defendants choose to go to trial. But the test for effectiveness is quite lax. Courts routinely condone mediocre lawyering, often because conviction seems to have been inevitable no matter what the lawyer did. The courts also have fleshed out the Sixth Amendment's other requirements, stating with the right to a speedy and public trial. The court has held that the failure to begin a trial in a timely manner required dismissing the prosecution entirely. Perhaps because the remedy is drastic, the court has interpreted the term speedy quite leniently. Delays for several years are sometimes permissible. The court has enforced the public aspects of the trial right much more strictly. Criminal proceedings may be closed to the public and the media only for overriding reasons such as national security, public safety, and victims' serious privacy interests. The compulsory process clause, the court has confirmed, lets defendants subpoena witnesses to force them to testify at trial. This clause, combined with other constitutional provisions, also now impliedly guarantee defendants the right to testify in their own defense, if they wish. The confrontational clause requires prosecution witnesses to testify under oath and subject to cross-examination, except for small children who would be traumatized by the process. They must also testify in court in the presence of the defendant to preserve the integrity of these confrontation requirements. The court also held in Crawford versus Washington 2004 that the prosecution may not introduce other court statements by non-testifying witnesses when those statements are testimonial, that is, when the statements were made primarily to establish facts for the criminal prosecution. So if, for example, the police investigate a crime and the witness identifies the defendant in order to have him arrested and charged, the prosecution cannot use the statement as evidence in court against the defendant unless the witness is brought to court so that the defendant can cross-examine him. Finally, the compulsory process, the confrontation clauses, guarantee the defendant's right to be present in the courtroom throughout his trial, though he can forfeit this right by behaving badly. That leaves the right to trial by an impartial jury. The court has held that this right applies whenever the accused faces more than 6 months' imprisonment and applied to any fact other than a prior conviction that would affect the permissible sentencing range. A jury must come from a pool representing a fair cross-section of the local community. Despite the history to the contrary, a jury may consist of as few as 6 members, though nearly all states require the traditional 12. The jury trial clause, combined with the due process clause of the 5th and the 14th Amendments, also forbids conviction unless the prosecution proves every element of the crime beyond a reasonable doubt. And the jury's verdict must be unanimous, though the court declined in 1972 to enforce this requirement against the states. Louisiana or Oregon, therefore, had continued to allow non-capital convictions by 11 versus 1 and 10 versus 2 votes. Consistent with its historical purpose, the jury retains the power to acquit regardless the strength of the prosecution's case or to return logically inconsistent verdicts to mitigate punishment. The Supreme Court has refused to hold that the Sixth Amendment entitles defendants to have juries instructed about the power or even advised about the sentencing consequences of the charges. Thus, while juries have continued to serve the role of as fact finders, and they left today to perform the traditional role as a circuit breaker in the state's machinery of justice, largely in the dark. Matters of debate. The first perspective is the full promise of the Sixth Amendment by Jeffrey L. Fisher. The Supreme Court had done much in recent decades to implement and to fortify the prosecutions of the Sixth Amendment in our ever-changing criminal justice system. But there's still important work that can and should be done. More than anything, the court needs to revitalize the right to jury trial in a criminal case, and the right guaranteed both in the original Constitution and the Bill of Rights. At the time, the founding jury service was honorable work, a key component of citizenship, as Alexander Hamilton remarked in the Federalist number 83, the friends and anniversaries of the plan of the convention. If they agree on nothing else, concur, unless in the value, is set upon the trial by a jury, or if there is any difference between them, it consists of this. The former argued it was a valuable safeguard to liberty, the latter represented as the very palladium of a free government. Nowadays, adults often grade a jury summons with duration as annoyance to be avoided if possible. This, no doubt, is partly due to the fact that the Supreme Court has allowed the lower courts and legislature to whittle down the jury's official job to nothing more than a fact finder. Juries are commonly told they should not concern themselves with punishment, and that they must find defendants guilty if the prosecution prove all the factual elements of the crime charged. There is a good reason to think that the Sixth Amendment should allow defendants to demand that then juries be instructed of the full scope of their power. First and foremost, juries should be told what potential punishments would follow from any given charge. Members jurors should also be told explicitly of their notification power. Fully informed jurors would embolden more defendants to proceed to trial. It also would provide a powerful antidote against the modern incentive legislatures had to expose defendants to exorbitant sentences for run-of-the-mill offenses, and thereby allow prosecutors to threaten to seek such sentences unless defendants plead guilty. The composition juries should also better mirror historical practice. State systems that allow convictions by non-unanimous verdicts or juries of fewer than 12 members should be declared unconstitutional. Furthermore, prosecutors should not be allowed, as they currently are, to prevent people from serving on capital juries simply because they have qualms about laws such as the death penalty. An impartial jury must come from a true cross-section of the community. Defendants, therefore, should have a Sixth Amendment right not to have juries stacked with jurors who, for example, firmly believe in capital punishment as legitimate and appropriate. Moving on to other components of the Sixth Amendment, the Supreme Court rightly construed the Confrontation Clause in recent years to prohibit the introduction of testimonials, statements of non-testifying witnesses. The court should clarify that the testimonial statements include not only those prepared as a substitute for trial testimony, but also those made with reasonable anticipation that they would aid a criminal investigation. As Professor Bibas notes, the ones among criminal cases never proceed to trial. Courts, therefore, should focus on whether the court's statements serve an investigatory role. If so, they should be subject to the Confrontational Clause. This rule should apply equally to reports by forensic analysts, including autopsy reports. Every year, scientific evidence plays a larger role in the criminal justice system. And much of this evidence is not nearly as foolproof as the public may believe. If a defendant wishes to insist that the prosecution present live testimony from forensic analysis, the Sixth Amendment should allow him to do so. Various allowances, particularly as things like video conferencing technology improved, might be made to make testifying easier, but court should not be allowed to dispense with confrontation altogether. If a live testimony is impossible because, for example, an analyst has died, then the witness's report should be inadmissible. That is what happened regarding eyewitness testimony, and forensic testimony should be no different. As for the right to counsel, the Supreme Court issued a critical decision, in 2010 in a case called Padilla versus Kentucky, holding that appointed lawyers must tell defendants whether convictions will lead to deportation. The court was correct to hold that lawyers must advise clients not only about potential incarceration, but also about such a significant collateral consequence. Deportation is sometimes more important than any jail sentence. Defendants should argue in coming years that its right to adequate counseling also requires notifying defendants of consequences such as being required to register as a sex offender and similarly substantial consequences. Next perspective. Effective lawyering and the vanishing jury in the world of plea bargaining by Stephanos Bybos. I guess. I'm not too sure. The founders would have a hard time recognizing modern American criminal justice. Lawyers and judges made the rules of procedure that evidence too complex and time-consuming. In response, courts have blessed number of efficient but dubious shortcuts, ranging from smaller non-unanimous juries exerting enormous pressure to plead guilty and dispense with trials at the need for proof beyond reasonable doubt. Thus, juries hear only a small percentage of criminal cases. About 95% of defendants plead guilty, usually in exchange for a plea bargain for the lower sentence. These cost-cutting measures have come at a high price, making criminal justice hidden, opaque, and impenetrable to non-lawyers. They count out jurors' common sense and their check on harsh punishments and overzealous persecutions. To improve matters, we should take the following measures: concentrate our limited funds for appoint defense lawyers for more serious crimes. Merely felonies make it easier for defendants to defend themselves in the most minor cases. Limit some pressures to plead guilty and streamline jury trials so that it can be more widely available. But some of these changes are matters for courts interpreting the Sixth Amendment. Others require legislative reforms. Not everything that is wise or fair is required by the Constitution. Currently, defense lawyering for the poor is a mess. The Supreme Court has made the Sixth Amendment right to appoint lawyers too broad, reaching not only felonies, but also misdemeanors involving any jail time or even a suspended sentence. But even after courts announces the new right, legislatures must decide how to implement and fund it. Criminal defendants are hardly a popular constituency. So indigent defense is chronically underfunded. Thus, public defenders and other appointed lawyers must juggle hundreds of cases at a time, often meeting their clients for the first time and immediately urging them to plead guilty on the spot. Public defense lawyers have little time or support to investigate cases, question witnesses, and prepare vigorous defenses. Courts should instead limit the right to appoint lawyers to felonies punishable by a year or more in prison, plus most serious misdemeanors, including those that trigger serious consequences like deportation. Appointed defense lawyers should have the time and investigators needed to prove each defendant's guilt instead of telling so many to plead guilty right away. They also need time to training to earn their client's trust, help them understand the pros and cons of the deal, and explain the consequences that flow from a conviction, including whether a defendant will be deported or lose his job or home. Legislatures should thus peg defense lawyers' caseloads, salaries, and support to those of persecutors. courts could even find that defense lawyers whose caseloads and resources are far offline are presumptively unable to provide the effective assistance required by the Sixth Amendment. By contrast, crimes with little jail time or only suspended sentences should have more simpler rules for evidence and procedure, like a small claims court, so ordinary people could defend themselves with little help from the judge and court clerk. Courts should not require appointed lawyers in such cases, at least where the rules for procedure and evidence are simple enough for non-lawyers to navigate by themselves. The founders thought the jury trial right was even more important than the right to counsel. It is backwards that a court requires lawyers for minor cases that do not trigger jury trials that are thus much simpler. Legislatures should also limit the kind of threat that could coerce even an innocent defendant to plead guilty. A modest discount of 10% to 20% enough to compensate guilty defendants for saving the time and expense of trial and giving up the small chance of acquittal. But larger discounts for 50%, 80%, or even 90% can tempt even the innocent to plead guilty. Some defendants will accept probation or short prison sentences simply because it's too risky to insist upon going to trial. Likewise, being jailed pending trial can pressure innocent defendants to plead guilty to minor crimes in exchange for time served. To limit plea bargaining coercion, legislature could cap post-trial sentences and 120% of the plea bargain offer, reviving jury trials as more realistic options. Better yet, juries could play more of a role and the sentencing. The Supreme Court claims that the jury's guilty verdicts authorize the punishment that follow from them, and jurors rarely know what the punishment will follow, and are sometimes shocked by the actual punishments. Instead, juries could impose sentences members after considering the plea offer as well as what the defendant deserves. Minor crimes could be handled like speeding tickets or tried much sooner and faster, reserving pretrial detention for defendants who are dangerous or extremely likely to flee. Unlike Professor Fisher, I don't believe that the Sixth Amendment requires jurors to know or authorize punishment, except for the death penalty and for the line between felonies and misdemeanors. But I agree that these reforms would be wise policy, limiting pressures to plead guilty. Streamlining trials should extend not only to the rule of full procedure and evidence, but also to the kind of evidence that demand live witness testimony. The core of the trial is the face-to-face accusation by the victim and the other fact witnesses who saw the crime. With these witnesses, defense lawyers' cross-examination is the surest way to expose lies, foggy memories, inconsistencies, and other weaknesses. Thus, confrontation clause rightly bars using out-of-court interrogation as a substitute for live testimony. Many other kinds of evidence, however, such as well-established scientific testimony, are generally more cut and dried. Once in a while, defense lawyers genuinely want to question the way a drug analysis was performed, whether the analysis was competent and honest. In those cases, you can use compulsory process clause to force analysis to testify and can bring in other evidence to impeach the analyst's ability and credibility. Defendants also have a Sixth Amendment right to challenge the foundations of junk science. In recent years, hair analysis, arson investigations, and shaking baby serum have been shown to be deeply flawed and unreliable bodies of knowledge. But usually, it's far more important to give the defendant lawyers funds for his own expert so that he can spot any weaknesses, critique the prosecution's methodology and assumptions, and conduct his own tests. Even though a the defense lawyer in a shaky baby or arson case would like to question the coroner, it would be unjust to exclude the coroner's autopsy report simply because the coroner has since died, particularly since one cannot autopsy a body again later on. These forensic reports are not analogous to the police interrogation that the founders feared would be used to subsequent live testimony. The Sixth Amendment does not require excluding such forensic evidence where the witness is unavailable through no fault of the prosecution. So the confrontation clause does not require videotaping and photographing all such scientific tests and making them double blind. Doing so would be wise, so defense experts can more easily perform their own analysis and rebut the prosecution's version of events. Okay.